Welcome, everybody. I'm Erin Daly. I'm the Executive Director of Dignity Rights International, an independent nonprofit organization dedicated to protecting the human dignity and advancing the dignity rights of every person, everywhere. DRI has been hosting a series of reading group events, 1-hour gatherings of people who are committed to engaging in and sharing cutting-edge dignity scholarship and thoughts. The idea is to have conversations that are informative but informal. Videos of past events are available on our website at dignityrights.org. Today, I'm absolutely thrilled to welcome 3 extraordinary scholars to our DRI reading group to discuss their new book on dignity in international law, recently published by Brill. Now, some books are about theory, and other books are about practice, and some try to bridge the two. But this book, I think, is not so much about the theory and practice of dignity in international law, but about theory in practice. It forces us from its very first pages to confront very difficult questions about the meaning of human dignity and what it really means to respect the absolute and equal worth of every human being when we're confronted every day with injustice, exclusion, oppression, and other forms of national and transnational and international violations. In the interest of time, I'm going to dispense with lengthy introductions, which are available on the website. All of our guests have extensive international and domestic law experience in human rights. I'll introduce them very briefly, and then we'll begin our conversation. Andrea Gattini is Professor of Public International Law at the University of Padova. Philippa Webb is Professor of Public International Law at King's College in London and a barrister at 20 Essex Chambers. And Rosanna Garciandia is Lecturer in Public International Law at King's College in London and the Research Fellow in Labor, Exploitation, and Human Rights at the British Institute of International and Comparative Law. Let me begin with you, Andrea. Could you tell us, and I will ask you all to mute your mic, just so that we can all hear our speakers best.
Thank you, Erin. Oh, excuse me, Erin. It's okay? Do you hear me?
Yes, thank you. Hear you.
So, thank you, Erin, for the kind invitation. It was really a huge pleasure to see you and friends and colleagues, Philippa, Rosanna, and we could start, I think, what was the purpose of the book, why we choose the subject, the timing of the book. So all started with an inspiration by Philip Alston. I came across his article in 2017. He published in the Journal of Human Rights Practice, and the title was "The Populist Challenge Human Rights." And I would like to quote some words which really impressed me very much and gave me much to think about. And the words of Philip were, the point is simply that we cannot wait. We need to start acting. We need to do whatever we can to strengthen respect for international human rights. We need to commit to the principles in our own lives, in our own areas. We are going to need to operate in a much more creative fashion, both internationally and locally. The response is really up to us. It was such a strong call, and I felt really, I was ashamed, actually, that I realized that as a lawyer, as an international law professor, I had so many different topics and interests, and I didn't really realize possibly until up to that moment, the risk, the challenge, the danger time we are living. Let's say, the community of international lawyer commit to human rights. And so for me, it was the right time in 2018 to organize a conference at the law faculty of the law school in Padua, because it was the 80th anniversary of the racial law, the enactment racial laws in Italy. And so it was a way to commemorate this awful, this very dark episode in the Italian history and in Italian law history, so the enactment of the racial laws. And so I found that it was a right moment to try to make also a comparison between the discussion, the discourse. At the time, it was at the beginning in the 30s, discourse on human rights and human rights protection in the 30s, and nowadays. I wouldn't compare the rise of fascism in Europe, the persecution, Jewish persecution, which led to the tragedy of the Second World War and the Holocaust, with the time we are living. But as Philip said, really, there are times where we have really to stand up and to speak, to make ourselves heard about the risks, the challenges, the dangers which human rights are living nowadays. And so that was the inspiration of the book, to commemorate Jewish professors, Jewish lawyers who had been sent to Italian ones had been sent to exile or have been even murdered. And this was the case of a Italian for a professor of international law in Padua, already retired at the time. It was old. Mr. Catellani was already 80. Nevertheless, he had been killed in January 45 for being a Jew. And so that was a part of the idea of commemoration, of remembrance. And on the other side, which role could international lawyers play today, which is their responsibility today in order to protect, to enhance the idea of human rights in the angle, under the angle, in the prism of human dignity, the dignity. So I have to apologize, and and of course I was very happy to find the support, the commitment, the enthusiasm of Filippa and Rosanna, who participated in the conference. And then we started with the idea, they encouraged me actually, with the idea to transform it into a book, into a collective endeavor. And I'm very, very happy to have worked with Rosanna and with Filippa. The outcome improved enormously from their editing, from their work. And then I think that they will share my sentiment that, of course, there are some in the book. We also, for question of time or space, we could not cover all different aspects. Like, for instance, the topic in which you are really leading scholar, Erin, that means environmental concern. So the impact of environmental concern for the concept of human dignity as a human right. So I have to confess, we skipped over, but it's time now to discuss on all this with you. Another topic which we had, for matter of space, we had to leave aside is persons with disabilities. So physical disabilities, mental disabilities is a missing chapter. I have to confess. And then it was appalling. We didn't think about racial discrimination, racial in brackets, discrimination nowadays, like for instance against Black people. For us, I think it was really a shock to discover at the very end of our editing process. It was in March, in April, even May 20. So the killing of Mr. Floyd by a policeman in the US, it was a shock. And so we have to apologize for not having even thought about that. And well, so that's it.
Thank you so much for a wonderful introduction to this book. For those who haven't yet had a chance to read it, just to give us a sense of the kinds of things that motivated you. And certainly one of the challenges for those of us who write in this area is that it affects so many different parts of life that it is very difficult to do sort of a comprehensive assessment of dignity, particularly when it relates to the whole field of international law. So I sympathize with the challenges that you faced in choosing what to focus on. Rosanna and Felipe, I'd invite you both to also comment on that initial question, but I'm also wondering, Rosanna, what did you learn about the place of dignity in law from your work on the book?
Well, first of all, thanks, Erin, for the invitation, and thanks to Dignity Rights International for organizing this event and for inviting us to have this conversation with you and with participants. It is particularly timely as today is actually the International Day on the Abolition of Slavery, and next week we will be celebrating Human Rights Day. And as Andrea was saying, there are so many topics that could have been included in this book, but we hope that this conversation, which is probably the starting point of many others, is going to cover some of those aspects as well. On your question, I must say that one of the lessons I learned about the place of dignity in law comes actually from working with Andrea and Filippo on a book on human dignity and international law. We had the great opportunity to work with a number of fantastic colleagues who were and are experts in human dignity and human rights. And I think the idea of the book raised was already quite telling about the place human dignity occupies in law. As Andrea was explaining, it all began with the conference he organized in Padova, when traveling for conferences was still the rule rather than the exception. And that obviously brings very nice memories about the event and also about the conversations we had with participants about all these topics that we're covering in the book. So obviously seeing all the work materialized in this volume is very satisfactory, and we hope that it will contribute to the interesting ongoing discussions about how the notion of dignity can shape more effective human rights system. I think going more into the substance of the book and what I learned in that process about the place that dignity occupies in law, I think those of us who work in the human rights area, be it from the perspective of international law, philosophy of law, the practice of human rights in domestic courts, in civil society organizations, have consciously or unconsciously a very close connection to human dignity. It was placed at the core of international human rights treaties and regional conventions on human rights, and the practice in national and international courts has confirmed a central role of the notion of dignity in the law of international human rights. There are, I would say, two main lessons in this regard that I think we can extract from the book. The first one is that the concept of human dignity has contributed to the development of international human rights standards, from the Universal Declaration of Human Rights to all international and regional human rights treaties, and we'll obviously refer to some of them today. In some areas of human rights law, human dignity can serve to establish a minimum standard of treatment, and that is something that Pascal Edesen identifies in his chapter about slavery and contemporary forms of slavery. It can also be the basis for regional human rights courts to establish general principles that apply to contemporary forms of slavery, which he illustrates looking at cases of the European Court of Human Rights and the Inter-American Court of Human Rights. He mentions the Hacienda Brasil Verde case, a case of slave labor that I'm sure many of the participants are aware of, as an example of the place that human dignity can occupy in the decisions of regional human rights courts. And this is actually a trend that was confirmed in a more recent case before the Inter-American Court in 2020, the Fábrica de Fuegos case. And I'll briefly say a few things about the case. It's a case concerning the explosion of a fireworks company in Brazil, where 64 people died and 6 were severely injured. The factory operated without permission and did not comply with the minimum standards of health and safety, and it was deploying child labor. the court found that Brazil had failed to comply with its international obligations regarding labor inspections, and Brazil was actually found responsible for violations of the right to life and personal integrity of the victims. And what's interesting from our perspective here is that the judgment actually included many references to human dignity and to its strong link with labor rights. So I think this kind of judgment is a very good example of that role or that place it occupies. Human dignity can also be a regulatory idea of the law in areas such as migration and refugee law, as Christian Walter shows in his chapter. He does provide a very interesting analysis of the Global Compact for safe, orderly, and regular migration from the perspective of human dignity. And as he puts it, human dignity can serve as a foundational function in the protection of human rights. And at the more practical level, it can also be an instrument of interpretative guidance and a common value shared by the international community. The second lesson I think we can extract from the book about the place human dignity occupies in law is one that has to do with the challenges that the law faces in practice to ensure the protection of the dignity of individuals in a variety of contexts. And I'm sure Andrea and Philippa will touch upon some of these examples as well. In his chapter in the book, Christian Tomuschat addresses some of the challenges of the international human rights machinery. He acknowledges that many injustices have been repaired through it, mentioning, for example, that many governments have realized that the practice of female genital mutilation amounts to a fundamental violation of female dignity, and that many states have become aware of the unbearable situations in their prisons, just to give you a couple of examples. But he also emphasizes some of the limitations and the criticisms we often hear of the UN human rights system. He talks about the extremely ambitious objectives of international human rights treaties, and he walks us through the history of the creation of human rights treaty bodies and their evolution, pointing at some procedural limitations that obviously need to be considered. And one that I would emphasize is his reference to the reticence vis-a-vis NGOs, with the Human Rights Council not allowing NGOs to intervene when state reports are being examined and being confined to providing individual members with information material. And in the Universal Periodic Review, for example, the UN Secretariat being mandated to condense submissions collected from NGOs in a document of no more than 10 pages for general circulation, and NGOs having very limited possibilities of expressing their views orally. Throughout the book, we also have other contributors looking at challenges in other parts of international law or other areas. Michaela Frulli looks at international criminal law, for example, and again, she presents to us the achievements and the challenges ahead for international criminal justice. She looks at the impossibility of bringing to justice those who bear the greatest responsibility of mass atrocities, which has been impossible due to personal immunities protecting higher ranking state officials. And she shares reflections on how the more general global crisis of multilateralism may actually affect the future of the International Court of Justice. And I think connecting to something that we'll probably discuss later, which is the definition of dignity, some of those challenges have actually to do with the vague definition of dignity, which, as Matteo Sarso puts it in his chapter on labor rights, has been seen as one additional challenge for the protection of human rights. And here I would like to just point our participants, and I'll conclude with this, to the chapter by Stefan Kirchner and Timo Kuivurova. Actually, we didn't cover environmental matters, but we do cover the situation of indigenous persons, which to some extent are connected to that side of the protection of human dignity. In their chapter, they mentioned that human dignity is notoriously difficult to grasp as a concept from a legal perspective, as neither the nature of the concept nor its contents are entirely clear. So some understand human dignity not only as a basis for human rights, but also as a human right in itself. And it seems that it's quite difficult to get to a single permanent definition. but as they also point out, this legal concept of human definition may actually be more accessible, human dignity may actually be more accessible in international law than in domestic legislation, because domestic legislation tends to take a more positivist approach. So I think these are, and sorry if I spoke for too long, the kind of two main lessons that I would take with me about the place that dignity occupies in law.
Thank you so much for that. It's just so interesting how when we talk about these things, a lot of different issues just sort of interconnect. And you mentioned the issue of sort of the definitional question, and I think we will get to that later on, and we'll definitely follow up with that.
Erin, may I intervene? I don't know how you.
Sure,
you
please do.
To lead our conversation, but if I may, so just say some comments on what Rosanna said.
Sure.
Yes, I appreciated very much the contribution, but I appreciate all contribution, of course, but that one of the Stefan and Timo Koivurova on indigenous person, I really commend so reading of this type, because they took the idea very personally. So the title of their chapter is lawyers' role in the protection of human dignity and of indigenous persons. So you see, they really grasped our concept, not saying what is the status of a law and what is going on on jurisprudence and so, but really what lawyers could do in this regard. And so this is a second comment on the role of NGOs in this. Some authors pointed the role of NGOs, especially Thea Brown for the protection, respect of human dignity for the LGBTI plus community. And so there are references to the NGOs and their essential role, but also for the role of us, so the international lawyer as persons. So I think, Rosanna, you share, so it's my idea that what was really make some contribution special is their personal commitment on this.
Absolutely.
And again, I'm sorry, Rosanna, did you want to add something at this point about the role of, should we come back to that?
I was just going to agree with him, yeah.
Okay. All right, great. Andrea, let me ask you another question, sort of a more longitudinal question about how you see, and also sort of picking up on much of what Rosanna was saying, but how you see the role of dignity having changed in international law over the last 70 years since the UDHR was adopted. And make sure you unmute.
Yeah, I switched off my audio because I'm in a very loud surrounding. It's my office in Padova. It's on a street with much traffic, and this is rush hour for us now. So yes, in the last 70 years, of course, because you're thinking about the Universal Declaration of Human Rights by the United Nations, 48. But one of the purpose of the book was to remind us of what was going on in the 30s, in the 20s, in the 30s. So Rosanna mentioned the Anti-Slavery Convention 26, which starts is a sort of really beginning of all the history of human rights protection, and it had been ratified by more than 30 states in a very short time. So the doctrinal debate in the 30s about human rights, and not only by human rights, democracy, not only by the well-known specialist, very committed lawyers like Politis or like Lauterpacht, but also from somebody like Kelsen, who is known as being the father of the pure theory of law and extreme, so theoretical, formalist even.
Good morning.
Well, it's not at all true. Kelsen wrote, it was about human rights, a foundation of the constitution, democracy, and then his writings on international criminal justice during the war, just after the war. And so it's interesting to see that we are not so aware of the fact that the enlightened at the time in the 30s, they really committed themselves personally, even to like in the case of Kelsen being a Jew, and they had to be, so he went into exile. He was put out of a university, thrown out of university in Germany. And so there was a very vivid discussion, so debate on this before the Second World War. Unfortunately, there were too few. Well, anyway, so what happened in the last 70 years, starting from Universal Declaration? Well, Universal Declaration, the concept of human dignity in Article 1 is a cornerstone of all the machinery built up by the United Nations. And I say this on purpose because I know that skeptical could say, well, how can you establish a building on such a vague or, let's say, not well-defined concept, possibly not even a legal one, like human dignity? That sounds like a paradox. But I do that really on purpose to say cornerstone, because the committee, the drafters of the Universal Declaration came from very different cultural, they had different cultural roots, different area of the world, different ideologies, and still they found a common ground, in the concept of human dignity. So I think it's not really necessary, not even worthwhile, to spend time in saying what was the status of the concept, the legal status of the concept in 48. There was a parallel discussion at the time in Germany, as you sure all of you are aware, about the drafting of a basic law of a German constitution, and then which had been approved just 1 year later, enacted just 1 year later in 1989. And then you find the same Article 1 of a German basic law says a Menschenwürde is unantastbar. It's just the first paragraph of the first article of the whole German constitution. It means human dignity is untouchable. And then the discussion on what was the legal status, what would they mean by, and what after the Constitutional Court, what could do the Constitutional Court to about interpreting a line this concept, which is a norm because it's Article 1, Paragraph 1 of the Constitution. And that we have the same discussion. It's just a programmatic principle concept. You have to interpret in a reductionist way. That means only in exceptional circumstances, under very exceptional circumstances. At some time, unfortunately, even the European Court of Human Rights goes a little bit in this thinking, this mood of thinking, we take the concept of human dignity only as a last break, so to say, the last dike. And on the other side, there have always been in Germany, in German constitutional debate, those who say, no, it's not a matter of interpreting strictly, reductively, only for exceptional circumstances, but on the other way around. Expansion, the human dignity radiates light on all aspects of the German constitution in the most different fields. Has to do with civil liberties, has to do with institutional buildings, or for all aspects of a constitution. So as a proactive, I say proposal, but it means a programmatic foundation of a whole social, of the entire social contract. And so you can make a comparison. The foundation of an entire social contract on a domestic basis, so for states, or for the international community as a whole. I would dare to say that the idea at the time was to find it as a fundamental, foundational moment, not only for the social contract in a state, Germany, but for a whole world. Well, hopefully it's was just not wishful thinking. And in the years, I think that Philippa, Rosanna will agree on this, that the concept of human dignity has been very much studied also in international law, of course, but not so much as in constitutional law. Erin, you are just the testimony for that. And I'm very happy to see that among us there is also Catherine Dupre, Stephen Riley. Really appreciated enormously their work, yours, but their work on this. So the comparative study on the concept of human dignity on a constitutional set by Catherine, which has been published 6 years ago, gave me really much food for thoughts in my introduction on this, on the concept of human dignity in the century from before, so from the turn of the 19th century to the 20th to now. But I agree also with Stephen, I must say, who wrote not so long ago in 2019, I quoted an article of his in Ratio Juris in 2019, who said, Stephen, of course you can say it's not a good quotation, it's not an exact quotation, but he said that well, what really makes out the concept of human dignity expressed at its core is a cosmopolitan concern, which goes beyond the boundaries of one domestic system or the other domestic system. It's the concept itself, which must be understood in a cosmopolitan, global, international way. So even if international lawyers are lagging a little bit behind the constitutional colleagues, and how did it change in the last 70 years? Well, just to make the most obvious example, in the European Convention on Human Rights, there is no hint, no mention of human dignity. And then, nevertheless, European Court of Human Rights, starting already with some celebrated cases like Tyra in the late 70s, of course, said that you know, flogging was a violation of degrading, humiliating treatment, and of course against violates the very essence of the concept of dignity. And after that, the beginning of
I'm going to jump in if you don't mind, just because I do want to bring Philippa into this conversation. Yeah. And I also want to sort of follow up on some of the things that you had mentioned.
Yep.
When I was reading the book and your comments also, I've really wondered a lot about this relationship between dignity and sovereignty and state sovereignty. And I'm wondering if, and we can come back to some of these issues if there's time, hopefully, but I'm wondering, Philippa, if you wouldn't mind telling us a little bit about your thoughts about whether you see dignity as a challenge to state sovereignty or as an integral part of it. So I'll turn the floor to you.
Thank you, Erin. And it's a pleasure to be here and also with my co-editors. So in answering whether dignity is a challenge or an integral part of the notion of sovereignty, we have to look at theory and practice, which is what Erin opened with. So at first, if we look at dignity as a challenge to state sovereignty, and I'm giving away the ending to say it's both a challenge and an integral part. It's a challenge because the realization of dignity on individual or collective levels requires actions and resources that states are often reluctant to provide. It requires them to tolerate diversity and dissent that they find uncomfortable. And it may involve scrutiny of their internal affairs that they may resist. So just to make this more concrete with two brief examples. So one central concept to dignity, and another one that we weren't able to cover expressly in our book because it would have had to be a multi-volume set, is voice, freedom of speech. That I think we can agree is fundamental to human dignity, our ability to express our opinions, to challenge laws and policies, to protest, to debate, to expose corruption. But many states want to silence dissent. 130 countries right now have criminal defamation laws that imprison people for insulting a state authority or a state official or a state policy. A former official in Thailand was just sentenced to 87 years in prison for reposting videos on her Facebook page that were critical of the monarchy. And the Indian government under President Modi is using sedition laws to silence climate activists, students, and journalists, more than 7,000 people since Modi came to power. And a more personal and closer to home example, at least for Rosanna and me, is Maria Ressa, who we've been working with and who's spoken in our classes. She's a Filipino journalist who just received the Nobel Peace Prize, which will be awarded next week in Oslo. And the designation says it is for her efforts to safeguard freedom of expression, which is a precondition for democracy and lasting peace. And we could add to that to a precondition for human dignity. She's been publishing, editing, and writing hard-hitting topics in the Philippines, exposing the drug war and corruption. And for that, she is facing a series of prosecutions that may land her in jail for 100 years. Currently, she is banned from traveling from the Philippines to Oslo next week to receive her prize. So that's voice. The second concept is equality, and equality in all areas. But if we just take gender for a moment, achieving the dignity that comes from gender equality requires enormous resources, enormous efforts, because you're turning back structures and generations and mindsets that have been very ingrained. And the Global Gender Gap report of this year, issued by the World Economic Forum, found that it will take 135 years to close the gender gap globally. It was 99 years last year, which is already very depressing, but it's increased by 36 years due to the impact of the pandemic on women. So on the other hand, dignity is integral to sovereignty. There's many ways, and Andrea and Rosanna have already touched on them. Dignity breeds mutual respect, recognition of equality in principle, if not yet in practice, enhanced communication, smooth international relations, recognition of self-determination and other human rights. And the most vivid examples of the link between dignity and sovereignty are the quest for statehood by various entities, so Palestine, Kosovo, West Papua. Whatever you think about their viability or their legitimacy as states, what is clear is that recognition as a state is so fundamental to how they perceive, they being the people, their dignity. It goes hand in hand with that concept. So I'll stop there, but my answer is it's integral and a challenge.
Thank you so much. Right. This is so complicated. I also want to mention, just because you mentioned sort of the connection between individual dignity and sovereignty, sort of for self-determination purposes, there's also the question of Indigenous sovereignty, which is important in the United States, and we happen to have an Indigenous chief, at least one, among in our group today. So I just wanted to mention that. I also wanted to mention, Andrea previously had mentioned both Catherine Dupre and Stephen Riley, both of whom have been guests in this program before. So we're very delighted to have them back here as part of the audience now. Let me just turn to you and sort of pick up, Rosanna, on some of the things that we were talking about before, which has to do with the role of the lawyer in protecting human dignity, sort of going to the practical questions of what should lawyers do, what should we be thinking about, and how can those of us who are in this world, in this theoretical world, encourage lawyers to pay attention to protect human dignity. Thanks.
Thanks, Erin. Well, actually, one of the motivations we had as editors of this book, and that touches upon something you mentioned at the very beginning, was that the theoretical reflections about human dignity that are shared in the chapters contributed somehow to shaping the practice of lawyers at the domestic and the international level. And that is why we asked our contributors to reflect in their chapters on the role that international and domestic lawyers could play in protecting the dignity of individuals and groups of individuals. You're mentioning indigenous communities, and obviously for some of those areas, we're looking at the individuals, but also at the sense of community. That resulted in specific proposals and recommendations, as well as some more general reflections on the role of lawyers in protecting dignity in a variety of areas. And I'll just briefly mention some examples of what I mean by this. In his chapter on social rights, our colleague at King's College London, Octavio Ferraz, presents very interesting reflections on what he considers is an often counterproductive judicial enforcement of socioeconomic rights at the domestic level. And he does conclude that international human rights law works most effectively through domestic political mobilization. On this basis, he considers that international human rights lawyers have an important role to play in supporting domestic struggles that use international human rights law mostly as a political tool, for example, to promote legislation and policy in areas such as health, which is so topical at the moment, unfortunately, or education. By the way, his chapter sends a very encouraging message about the achievements in the protection of human rights. So those of you who are working in civil society and may need some encouragement, this is one of the chapters to turn to. Back to Stefan and Timo's chapter, looking at the role of lawyers in the protection of human dignity of indigenous communities, they emphasize the idea that human rights are realized first and foremost at the local level, and that lawyers need to pay attention not only to legal victories in courts, but also to how these judgments are enforced and implemented in reality. And they do argue that in the daily practice of law, the focus is usually on specific human rights rather than on fundamental concepts such as human dignity, with human rights being a concrete, practical realization of human dignity. And I think a good example of this is the landmark decision of a German court earlier this week, finding a former member of ISIS guilty of genocide over the death of a 5-year-old Yazidi girl he had bought as a slave and chained up in the sun to death. So this is probably one of the best examples of this. Also, Andrea was mentioning Tia Brown's chapter. In her chapter, Tia refers to an aspect that I think is key to understand the role of lawyers in the protection of human dignity. The role of international lawyers working closely with local human rights defenders and local lawyers who have played an important role in advancing human rights, including the right to dignity. She's referring to this in the context of sexual orientation and gender identity, the topic she focuses on, but I think this can also be said of other areas. The contribution of international lawyers advising local lawyers and human rights defenders is of essence, I think, as part of their contribution to the protection of human dignity. Philippa was talking about freedom of speech and the pressure that some human rights defenders are suffering. International and regional human rights treaties set up standards, sometimes various standards that have to be applied at the domestic level, but it may not be clear for local lawyers or human rights defenders how those standards translate into the domestic system. And that is, to some extent, one of the places where international lawyers can play a key role. And that is something that we have also identified when looking at the reality of migrant workers, particularly migrant workers at risk of domestic servitude. This is an area that Philip and I have been researching for quite some time now, and where we see that there is a clear role for lawyers. A variety of international treaties create obligations for states to protect migrant domestic workers from trafficking, from exploitation, and yet this continues to be a terrible reality for many of them. In some cases, there is a need for stronger domestic frameworks or policies, or for more effective implementation of those. And in other cases, the way in which victims are treated and referred to in judicial proceedings may be offensive, gender biased, race biased, and actually constitute an additional threat to their dignity. So in all those situations, international and domestic lawyers have a very important role to play. They can participate in many ways in shaping the definition of human dignity that applies in this context, when they are defending victims, when they are advising states on what exactly are the international standards that apply in this area, or when they are drafting and applying international rules and decisions. In all those roles, incorporating the gender and the race dimensions of human dignity in legal practice should be a priority. They should contribute to guaranteeing a definition of human dignity that, or an application of the definition of human dignity that protects migrant women, in this particular case, from the risk of being subject to domestic servitude. That's a contemporary form of slavery. And I guess I'll just finish with a quote from one of the chapters, the one on indigenous communities by Stefan and Timo, where they say that it is in the protection of human rights through the creation, application, and enforcement of laws which reflect human rights that lawyers in their diverse professional roles contribute to the protection of human dignity. I think this quote encapsulates quite well the multiple and very important ways in which lawyers can make a difference in shaping and applying legal frameworks that are more protective of human dignity.
Thank you so much. Such an interesting and sort of wide-ranging response to this question. And I love where you sort of began with the notion that this is really so important at the local level. Even when you're talking about dignity in the context of international law, we're talking about all these abstract concepts. And really what it's about is the experience of human beings and how they are treated by others and by the state. And as we draw this conversation to a close, I have a couple of additional questions. One for Andrea, sort of picking up on this, and then we might have questions from the audience too. One for Andrea, picking up on this, is just whether you recognize a particular definition of dignity or a specific understanding of what it means. A lot of people start their conversations about dignity saying, of course, there's no definition for it. But I wonder if in this work you've developed one. And I would also, if we have time, I would also invite audience members to write their questions in the chat and or raise your hand if we have time. Thanks.
Thank you, Erin. Well, as we said in the back cover of our book, use the terms like classical concept in public international law. Then we said a core element of a human rights machinery. And so I think consciously or unconsciously, Filippa, Rosanna, and I avoided to a certain extent to take a strong position on a strict legal definition of human dignity, preferring to use a vocabulary which is a little more open or open-ended. So I think all of us are we all well know McCradden contribution more than 10 years ago in the European Journal of International Law on legal definition of human dignity, but his angle was in the context of jurisprudence, what a judge can make out of the concept of human dignity, and not a legal concept as such. Just it was the angle of judicial interpretation and application. Not just reminding what McCradden said, but is multifaceted. You can have under a substantive, there is a substantive content of the concept of human dignity, and then there are some procedural aspects which are as important, where the concept of human dignity can be of very much avail. So as a balancing factor or possibly conflicting rights, especially for the test of proportionality. Then as a developing concept, that means you can take some concept, legal principles or norms, and you can interpret it in a, let's say, in an innovative way, in a progressive way, using the concept of human dignity. And then, of course, it's a tool for the judge to, in a judge-made law, just to use it as a creative tools to extract from some other principles, some other rules, new expressions. For instance, for the self-determination, let's say, so well, development of the individuals or groups. So I think we should take cognizance that the concept is multifaceted, being really the foundation of all the machinery of human rights protection in our age. So it could have a different shape. It could be that in some fields it's a principle, a general principle of law. Rosanna mentioned the Sena use it as a general principle of law in the classical meaning, in the field of slavery and well, of course, anti-slavery field. In some other fields, I'd say its potentialities are still underexplored. So it's not by chance. It's a very impressive book, a very impressive study on human dignity, a recent one, which put in a comparison or together human dignity and human rights, is by Pablo Gilibert. And I think it's not by chance that Pablo come from studies on poverty, so global poverty studies. So and you see it again, this link between the concept of human dignity, poverty or extreme poverty, in the discussion about undocumented migrants. So it's interesting to see how and this is a contribution by Francesca Ippolito in our book on the jurisprudence of European Court of Human Rights on the matter of the undocumented migrants and which rights you can recognize, and so. And it's interesting to see how it uses the concept of human dignity, sometime in making stronger the argument for the protection of undocumented, for rights, recognition of rights of undocumented migrants. And sometimes it's a little more restrictive, it doesn't go so far. So when it touches very sensitive questions like security, access to public services, and so you see that the human dignity as potential in some fields as potentiality will not yet really explored or developed as they, in my opinion, should.
Thank you so much. Really a lot of very interesting comments. We do have a question from the audience, and if the audience would just beg our indulgence for a few more minutes so that we can hear more questions, that would be great. Carolina, would you like to, if you'd like to turn on your video, that would be great. And if not, we would love to hear your question.
Thank you. I'm unable to turn on my video right now, but I hope you can hear me. Thank you so much for the really interesting introduction to the book. And my question kind of leads on from your previous comments, so actually fitted it in quite well, in a sense of what guidance would you give for building a more determinative concept of dignity in terms of how judges can use it to interpret and guarantee rights? So I'm looking at the European Convention on Human Rights, and as you mentioned, this concept of dignity is at times used to advance rights, but in other times, especially in the kind of politically sensitive issues, judges are almost taking too cautious approach in order to respect state sovereignty. And I'm just wondering if you have any advice in sort of building a more kind of determinative, normative content of what is required from this human dignity?
That's a fantastic question. Thank you so much. I'm wondering, Philippa, if you'd like to take a stab at responding. Thanks.
I can have a first run. Thank you, Carolina, for that question, which is certainly, I think, going to leave all of us with food for thought. I mean, two initial thoughts from me. I think the two approaches to try to make this complex, somewhat vague and mutable concept into something that judges can interpret and use to guarantee rights is, first of all, to link it more closely to human rights. So that was what I tried to do in my intervention earlier on, talking about voice and freedom of expression and how integral that is to dignity. That's not something that you tend to see judges look at. That's not how freedom of expression is spoken about in the European Convention on Human Rights, for example. But if there could be more discussion like that through lawyers, as Rosanna was saying, finding ways to shape and interpret legal frameworks, bringing in notions of dignity, and just showing how, freedom of expression, voice, and how that's integral to dignity. Freedom from slavery, obviously integral to dignity, but even right to property and how that's integral to dignity, and pulling yourself up in the world and protecting what you have. At the same time, because rights, especially in the European Convention, are so individualistic, and one of the things that's sort of been coming through is we need to be very aware of collective rights, indigenous rights, economic and social rights. So I would urge that that's not lost in trying to link human rights in a conventional sense more closely with dignity. And the second approach, I would say, is to disentangle the type of dignity we're talking about from the dignity of the state. Because we have states coming in, and a big field I work in is immunities, and you have states coming in saying, because of our dignity or the dignity of our high officials, we can't even possibly even be in these proceedings, let alone engage on any level, let alone have there be any remedy. And I think we have to disentangle that concept of dignity, maybe just call it immunity, but it's not a dignity, and really sort of recapture the concept for what Erin said, that human to human level, how we treat each other, and not let it be co-opted.
Thank you very much. That's really helpful.
Thank you so much. Are there other questions from the audience? I know we're out of time, but I'm interested to hear if there's other questions. If not, I just have one perhaps brief question, perhaps not, for Philippa, to just sort of build on that and sort of connected to very much of what we've been talking about, but more broadly, what do you see as the future for dignity, for human dignity, to be specific then, in international law? Where do you think it's going?
So, and this links with what Andrea said earlier, and I want to take the opportunity because I did find the book. I've just moved house and I found it in a box so I could hold it up. Rosanna has it too. And I want to turn to Andrea's introduction, page 3, where he says, and this is, I think, the roadmap for the future. The concept is in need of some reconsideration to better fit contemporary social and cultural norms, such as the dignity of children, of persons with disabilities, of women, of those fleeing armed conflict, and finally, of all creatures. And I would add to that, and it was a non-exhaustive list, I would add to that Indigenous peoples, the environment, and also intersectional approaches. What does it mean to have dignity as an undocumented migrant woman worker? So I would say that's the roadmap. And I just want to end with going back to a case Rosanna mentioned, the German court judgment this week against an ISIS member for genocide against the Yazidis. So my friend Amal Clooney was counsel in the case for the mother of the 5-year-old girl who was killed by the ISIS member. And after the judgment came out, she said, quote, "This is the moment the Yazidis have been waiting for, to finally hear a judge after 7 years declare that what they suffered was genocide." And I think in that case and in that quote, and here is a lawyer motivated by enhancing human dignity, we see the connection between, quite a conceptual, abstract level a 1948 Convention on Genocide. What does national, ethnical, racial, or religious group really mean today? Where's the evidence? Where's the specific intent? And the local human reality of how we treat each other. And the Yazidis have suffered so much. They've had their dignity harmed again and again, but their joy and celebration at this judgment against a single person shows that actually lawyers can have a role in restoring dignity to people, and it might just be one case at a time.
Thank you so much.
Erin, excuse me.
I was just going to ask if you did.
No, well, just no, because this would bring to close the cycle our conversation, because both Rosanna and Philippa mentioned a decision by the German Constitutional Court. There is another one decision, not so recent one, this spring, about the claim by the Fridays for Future, constitutional claim, which has been accepted and by the Constitutional Court to deal with. And at the end, the Constitutional Court said that the German government didn't do enough, or Parliament even didn't do enough to protect the future generations from the disaster of climate change. And I wonder if this courage by the German Constitutional Court, if at least partly, they found it in Article 1 of the Constitution and the concept of human dignity, which, as I said, radiates not just a single aspect, civil liberties in a way or another, but the whole Constitution, if really meant and felt. And apparently, not this is a testimony that German constitutional judges took their task seriously. And so the Friday for Future case is really a milestone in the environmental concerns. So excuse me, Erin, that I just jump into.
Not at all. That's exactly right. And it's interesting to see how the cases do come, one after another, and more and more frequently at national and regional and supranational levels. So thank you for bringing those up. I'm wondering if I can ask everybody here in the Zoom room with us to turn on your microphones finally, just to give a round of applause to our guests so that they can actually hear live people here. But thank you so much for your conversation and for sharing the wealth of knowledge that is sort of embodied in this book, and that you've gained through the process of it. It's been such a pleasure to speak with you all and to learn more about it. And I do encourage everyone to buy the book, because it really is very, very thoughtful. Thank you. There it is. There you go. Thank you very much to everybody. Looking forward to
Thank you, everyone.
Really
Thank you so much.
Thank you. Bye-bye.
Bye.